specific question whether non-examination of the IO will be fatal to the prosecution. Lord, I have got two decisions, my Lord, which says it will not be fatal, my Lord. I have given the decisions.
Item.
There my 2 points, sir. FIR is not proved because informant is not examined. And the other is 4 DP Act, he has been convicted, acquitted, whereas 492 he has been convicted.
Yes, that I see.
The two things.
Written notes or something.
Which one?
In this case,
Particular case.
The same. Written note.
That may be kept.
Yes, thank you. Any mentioning?
Item 39 notice.
Sir, let me pronounce the judgment. Couple of judgments are there.
your lordship, 64 item ro kali file ta sir asipawni apna.
Can I just pronounce the judgment first?
Yes, no, no, এটা ମୁଁ ଶୀଘ୍ର କାଲିର ମାନେ on Thursday ର କହୁଥିଲି।
What do you want?
ସାର୍ ଫାଇଲ ଟା ଟ୍ରେସେବଲ ହେଇପାରୁନି, ଫାଇଲ ଟା ପାଇଁ କହିଥିଲେ କିନ୍ତୁ ସେ ଆମକୁ ଦଉନାହାନ୍ତି ଫାଇଲ କିଛି, କହୁଛନ୍ତି ନାଇଁ ତ ଆପ୍ଲିକେସନ ଲେଖ।
Give deposition please. What are you asking for? The entire file or deposition and all?
ଫାଇଲ କାରଣ ସେ ତାର ପିଟିସନ କପିଟା ବି ଆମ ପାଖରେ ନାହିଁ, ସେଇଟା ଟିକେ ବି ଦରକାର ପଡୁଛି କଣ କାରଣ ସପୋଜ ହ୍ୱେରେଭର ପାଇଁ ପଚାରିବାକୁ ଗଲା ବେଳକୁ
Petition copy, what is the problem? Petition copy, then we have problem. These are not classified documents. These are the part of the court proceeding. What is great in it?
Judgment is
Won't be a problem. I mean, these are not classified documents. These are court proceeding and court paper. All these things are happening in the open court. What is wrong in giving? It is for them only, for litigants, for the prosecutor. Why should we keep it secret? Give it to them. They'll give it.
yes sir, obliged.
The apprehension is it is misused and all.
Again. But
And who is going to misuse 1992, 93 matters? Everybody is interested to get rid of these matters.
Yeah, roll up, please.
Yes.
Item 1.
The appeal is partly allowed, and I have recorded the appreciation for the effective assistance rendered by Agnishika Roy, the amicus curiae.
Brief.
Item 2.
The appeal stands dismissed. The appeal filed by the informant.
Item 3.
I have confirmed the conviction, however, granted the benefit of probation of offence act under section 4 of the act, and 5,000 fine is also partly allowed.
Item 4.
The sentence is, the conviction under 498A is upheld, but the sentence is reduced down to the period that already undergone.
Item 5.
Conviction is upheld and the sentence is modified. And I have also put on record the appreciation for the assistance rendered by Mr. Sankar Mishra for as an amicus curiae.
Item 6.
I partly allowed the appeal while upholding the conviction, granted the benefit of section 4 of probation of offence.
Item 7.
Here also the conviction is upheld and section 4 benefit is changed.
Item 8.
In this case also the conviction is upheld and benefit of section 4 of probation of offence is.
Item 9.
The criminal appeal is allowed and the appellant is acquitted from all the charges.
So 10,
Insofar as the charge under section 307 IPC is concerned, the appellant is acquitted. However, the appellant is found guilty of offence under 376 IPC. Since the entire sentence has already been undergone by the appellant, no sentence for the sentence will be imposed.
item 11,
The appellant is acquitted from all the charges and bail bond stands discharged. Appeal is allowed.
12,
The conviction is upheld and benefit of probation of offenders act is extended. Partly allowed.
13,
Here also the conviction is upheld and the benefit of section 4 of offenders act has been granted.
item 14,
Here also conviction is maintained and the benefit of section 4 of offenders act has been extended.
item 15,
Here also the same conviction is maintained and section 4 can be granted, partly allowed.
item 16,
Here also the conviction is maintained and the section 4 benefit is granted. And I have record the appreciation of the assistance rendered by the amicus curiae Rakhi Mishra.
17,
Conviction is maintained, section 4 benefit is granted. And I record the appreciation of the effective assistance rendered by Onsuman Roy, the amicus curiae.
18,
The criminal appeal is allowed, the appellant is acquitted.
19,
The criminal appeal is allowed and the appellant is acquitted of all the charges. I have recorded the appreciation of the assistance rendered by Vikuna Mishra, the learned amicus curiae.
20,
Conviction maintained and provision of offenders of conviction.
21,
The conviction is maintained, sentence is reduced down to the period already undergone. And the fine is increased to 10,000.
22,
Conviction maintained, benefit of section 4. Granted.
23,
Conviction maintained, insofar as sentence is concerned, section 4 benefit is granted and fine amount is remained untouched.
24,
The conviction is maintained and sentence is reduced down to the period already undergone.
25,
The conviction is maintained, the sentence of 2 years is modified to the sentence.
3 months.
No,
Sentence of 3 months.
no, this is
25 sir.
Tikayat Behra. No,
25 sir आपण
And more.
नाही.
already undergone.
26,
26. Possibly benefit of. Section 4 benefit granted, conviction 19.
27,
If the appeal is allowed, the appellant is acquitted.
28,
Also, the conviction is maintained. Section 4 benefit is granted.
29,
Conviction is maintained and section 4.
30,
This, the criminal provision is the impugn order. I find no reason to interfere in the impugn order. However, directly the trial court to expedite the trial to finish the trial within a period of 9 months.
31,
The criminal miscellaneous main is partly allowed insofar as the petitioner is concerned, but insofar as the form is concerned, the PMLA proceedings shall continue.
Your Lordship, item number 39 is there, my lord.
Yes,
Item number 39.
13.
307, it is coming after 20 years, my lord. But I was verifying, I have no document with me. 307 case, so therefore documents are necessary for Lord,
You want some?
preparing for the hearing. I want some time to.
Okay.
I have already telephoned yesterday. That is
This
also
is 98 matter.
98 ର conviction. FIR.
Then what you ask, you tell me which date you want.
2 ସପ୍ତାହ ପରେ ଗୋଟେ date ରହୁ ମୁଁ I will
14th,
take the
14th, 14th.
yes
Item 13.
39.
39.
39.
Oh, 39.
Yes.
Or 2005 matter.
2005 is.
2005, 39. No?
Your Lordship, item number 57.
1 minute, let me finish it. 39, okay.
Madam.
14.
Take a longer time. 2005 appeal. August 29th August, 29th August. 29th August.
29th August.
20. Yes, yes.
Item 57, pre-adjournment.
57.
57. Item of 2006.
I'll call for a report. Call for a report. You tell me sit.
Pardon to mention, my lord, item 40, a copy of the brief is not available with us. We may be permitted to reconstitute the copy of the brief.
40.
40.
Okay.
Or let's say maybe taken up after 1 week.
Okay. The counsel for the appellant is seeking an adjournment to reconstruct the file. Yes. Okay.
Item 37.
Mr. Ashok Mohanty has some doubt. What he's asking, some doubt. Acha, copy. I'll just upload it immediately today itself. I have given that benefit of section 4. It's open.
Item 37.
Yes.
Goes time.
30?
37.
37. Okay. Okay. 2 weeks. 37. 55. 55. 1 minute. 55. Okay. 55. Take it.
Item 58.
Simply resume.
58, my lord. Item 58, my lord.
58. Okay.
Can be taken up after 2 weeks, my lord.
58.
Well,
Okay.
Item 46, my lord.
58. 1 minute. 58. 46. What happened? 46, what do you want? 46. I'll call for a reports, 80 years.
My lord,
47.
here-
No,
I'm calling for a report.
no, my
my
lordship,
lord, 40
actually, just died, my lordship.
Died?
I have a glass to the last
Eh,
order.
1 minute, 1 minute. 49, na?
46, my lordship.
46, okay. 46. Let us see.
They have given the death certificate and last order, my lordship.
my lord, in 46, my lord, the appellant is already died, my lord. I already implemented his
Okay.
wife is a party man to contest the case, my lord.
394-2 application is there.
Yes,
Okay,
yes,
okay. He's asking for adjournment.
Your lordship.
My lord is already
No,
allowed, my lord, already allowed, my lord.
I know. You get ready and come. Okay.
Yes, my lord, 1 week after, my lord.
Yes. Yes.
Your lordship, item 47, 46,
Mhm.
47, sorry.
Yes, 46, 47. What do you want, madam? Which item?
46, 47.
47, okay. Yes, 47, what do you want?
I pray for adjournment.
Adjournment, 47, 1 minute. Okay. Sorted. Yes, let us start.
32,
Wait, please, your lordship. Item number 32, my lord. Here, your lordship, the police handed over to our member of Gosala 122 number of cattle, your lordship.
Mhm.
Without adding the Gosala as a party, because I am the custodian, without adding me as a party, the claimant filed 457 application before the learned court below, and without considering the proper position of law and the ratio decided by this honorable court in 2024 SCC online, Orissa 1338, he passed an order for release of the cattle, your lordship, in favor of the claimant.
Okay.
That starts from page number 15 to 21, your lordship.
Now, what was why it is listed before me?
Because I'm coming to that point, my lord.
Mhm.
I'm challenging the impugn order, entire impugn order, your lordship. Prior to my application,
Mhm.
the claimant filed one CR Limsi challenging the one of the condition of that impugn order. That is condition number C, my lord. Lordship 4435 of 2024 CRC may kindly perused.
44 the
35, another one, where I have filed intervention application and also record of that order application.
Okay. Hmm.
My humble submission, my lord,
This was
The-
allowed.
that is allowed because, my lord, they suppressed the material fact before this honorable court. They said, my lord, the YouTube link is available, starts from 27 minutes 10 seconds. They said the entire amount is 4,89,000, but the amount is 40 lakhs. They misrepresented before this honorable court. And they are saying,
Lordship, may I kindly see order dated
The order
7/1/25?
So the court directed the petitioner to deposit 2 lakhs rupees.
Yes.
50% of that.
Yes.
That is why I said 50.
yes, your lordship, but the amount is 40
40
lakh
lakhs.
89,000.
Where from I'll get it?
Yes, your lordship. Now, your lordship may kindly come to their petition only.
Hmm.
Page impugn order
4435, huh?
4435 is their petition.
Hmm.
My petition is 1620, your lordship.
Which one I'll refer?
Anyone, your lordship. The impugn order part.
Which petition you are referring?
1620 of 2024.
Your petition, huh?
My lord.
Okay. Yes. Where is the impugn order? Yes, I got it.
Your lordship may kindly come to page number
Yes.
19, paragraph number B, clause number B and C. I'm reading the C. The petitioner shall, as per the prescribed rate by the AWBI, furnish an amount towards the cost of incurred by the Jimadar for the upkeeping of animal at the rate of 200 per day. Per day. So, my lord, what they saying, my lord? They saying 142 cattle per day is 200 rupees per cattle and calculated the cost. And for 144 days, they said 4,89,000.
Oh, calculation problem. A
They-
figure has not come. Yes.
Yes, your lordship. And also, my lord.
Then I'll issue notice to them. Let them go.
But
Let them go.
in this
It
matter,
is
your
what
lordship,
it-
in the first one, stay is required. Because, my lord, they already lodged a case against our Gosala person under 406.
Stay of what?
Stay of the impugn order.
Which impugn order? The one which was earlier challenged,
Yes, your lordship.
which I have already modified.
That condition, your lordship, modified, not entire order, never perused, your lordship. Your lordship,
It seems the cattle have already been transferred to the hands of the petitioner in the other case. So without having
What,
the state,
yes, what will
I am the Gosala. The kettle is with me.
there is nothing on record to state that.
I am the Gosala. My version, your lordship will consider. I am the Gosala.
I'll record it. See, I'll see. Ultimately, the welfare of the cattle are
Has
more
to be-
important
Exactly,
than
your lordship.
your internal fightings.
Yes, your lordship.
So therefore, I'll have to protect the interest of the cattle.
Yes, your
I'll
lordship.
record your statement. If it is not,
There's nothing on record to suggest that.
where have you said anything anywhere in the petition?
Yes, your lordship.
It's not about the petitioner. You must see the
It is in order. What?
which was modified by your lordship, granting them time to deposit the money.
Deposit.
There is nothing on record to show that
Have they deposited?
I do not know, your lordship. That instruction has to be.
And in your petition, where have you said that what transpired after the
We
order?
don't know about this petition, my lord. We don't know. Your lordship will kindly come to the.
Yeah, then you show me in your petition, where have you said that the cattle are there with you?
Your lordship will kindly
Show
come.
me. As of today, the cattle are with you.
And let them rectify the mistake and have picked upon in their certificate, your lordship.
Hmm?
There is another CLMC which they sought for the recall of the order that has not been reflected in the certificate.
How? Because, my lord, what she's saying, my lord, in the first CR you what they filed, they're not adding me as an opposite party. We
Yeah,
don't.
therefore, you moved application there.
No, my lord.
Then?
They filed 457 application. I am the Gosala.
Don't you think that I understood it? The first matter, when they got the order without including you,
Yes, sir.
whether you have moved an application for modification is there,
No, no.
then why have you come? Substantive petition, why have you filed?
Because I am challenging the entire order which is illegal.
Oh, apart from that,
Yes, your lordship.
see,
They
listen,
challenge only the condition.
you are entitled to challenge, no problem. They are
Yes.
challenging, you are challenging, no problem.
Yes, your lordship.
I'll entertain, I'll issue notice that. But insofar as the interim order passed in the earlier order where the accused persons have challenged, there you move an application for modification and mention, I'll take it.
I have already filed, your lordship. I have
Where is
already
the
filed.
modification application?
Your lordship may kindly come to IA number.
In 4435,
Yes, your lordship. I am
where
coming.
is that?
1311 of 2025 is my
Where have you-
intervention application.
Okay, where have you said that the cattle are there with you?
Yes, your lordship. I have mentioned everything in the.
No, where, show me that part.
My lord, I am your lordship. My lord, come to page number 5.
5, huh?
The intervener organization has not received a single penny for care and maintenance of 144 number of injured and deliberate disabled rescued cattle from the claimant or from the accused, or both as per the liable payment. This is this. Prior to that, your lordship, the IO struggling with the daily expenses, the intervenant requested the IO cost of treatment, care and it is measure of the.
I am asking something else. Where have you said that the cattle have not been taken by them?
My
So,
lord.
till today, it is there in your under your position.
Your lordship. The rescue cattle were handed over to the intervenor organization for treatment, care and rehabilitation.
That we know it was handed over. After
Indeed.
the order, whether it was given back to the accused or not.
Not given back.
Show me where.
Because, my lord, I am the Gosala, your lordship.
You are not the Gosala, you are advocate appearing.
But I am
Show me,
appearing for the-
Gosala has to say in the petition.
Page
Where is
number
that?
4, paragraph number E.
E.
Yes, my lordship.
Yes.
ଆଜି ପର୍ଯ୍ୟନ୍ତ ଅଛି ବୋଲି ଲେଖିଛୁ ଆଜ୍ଞା ଆମେ ତ କହୁଛୁ ଆମ ପାଖରେ ଅଛି ସେମାନେ order
Where have you
ଦେଇଛନ୍ତି।
said, please show me that line. Why are you unnecessary wasting time? Where is that?
The total cost expenditure till 7/5/2025 is because till 7/5/2025 we are maintaining. तापर
You want me to infer it. But you file an affidavit, I'll put it on Tuesday. File an affidavit.
what I am saying.
File an affidavit saying that the cattle are still with us. Then I'll stay the order. Otherwise, unless it is there on the record, how can I do that?
I filed this application on 7/5/2025. Till that date, the cattle is with me, and I can file the affidavit. But my lord, I am the Gosala. The cattle is not handed over yet. I am saying the cattle is with me.
May I suggest you?
My submission is sufficient.
Why don't
I
you
think.
appreciate it's there is an order already passed in his favor. Without notice, I can't vary the order. If you want a stay, contrary to the order which I passed, something has to be there on record, not on the basis of oral statement made by. Then I have to issue notice and ask him. Either you file an affidavit or I'll have to issue notice. I can't modify the order in his absence. An order which has already been passed in his favor.
They are committed mistake. They are misleading.
I don't know because there is no
They
calculation.
misled this honorable court.
Okay, I'll issue notice.
I will file
Issue
affidavit and your
Issue
lordship.
notice to the in both the in the 4435 in IA number 1311 of 2025. Issue notice to the petitioner.
Two IAs are there, my lord.
Two IA.
My lord.
1312 and
One for
1311.
the intervention, the other one for the modification.
Recall of that
No,
order.
intervention I am allowing. Which is intervention?
1311 of 2025.
13 for the reasons stated in the application. The application is allowed. The Gosala. What is Gosala name?
Sri Sri Radha Madan Mohan Gosala.
Sri Sri Radha Mohan Gosala is implicated as opposite party number 2 or 3.
2 only.
Opposite party number
2, my lord.
2 to the petition. Insofar as 1312 is concerned, issue notice to the petitioner. Petitioner. Insofar as 1216 is criminal matter also, the petitioner is this. That one. The petitioner Gosala has assailed the order dated 20th September 2024, passed by Lieutenant JMFC R. Udagiri in Miss Case number 6 of 2024. Mr. Sahul, Lieutenant Counsel for the petitioner, submits that the impugn order was passed behind the back of the Gosala, who has been handed over the cattle after their seizure. As per the judgment of this court reported in so
2024 SCC online.
So the Gosala is a necessary party, at least while disposing with an application under section 457 CRPC. He further submits that pursuant to the order dated pursuant to the order dated 4/2/2025, passed in CRLMC number 4435 of 2024, the cattle are still under the possession of the Gosala. In that regard, he seeks 2 days time to file an affidavit. Let the petitioner file an affidavit to that effect and leave the matter Tuesday.
Grateful.
Lordship has issued notice in the 2025 CRM, sir.
Yes. Notice.
Much.
Notice to, in the meantime, issue notice to the respondents.
2 to 10, your lordship.
1620, yeah. Which Subolakshmi accept notice for the state and
Okay, 2 to 10.
2 to 10, yes.
Grateful, man.
And Mr. Sau is also granted liberty to serve the respondent note 2 to 10 through their counsel appearing.
They are not receiving your lordship. So मैंने कहूँ ना इसी कोई ला हम तो brief already पढ़ी
That notice.
So
was
notice is required.
4435, Mr.
ऐसे मना कर दिले हम मुझे भी नहीं कहले सिर्फ ऐसे ना.
Oh, that part you leave it. That part you leave it.
Grateful, your lordship.
Yes.
33.
33. Yes.
33 kindly has ordered 1/7/25 hours.
Call for a report.
And report is not required on the grounds, your lordship, kindly on 1/7/25. The 23 report is there very much, your lordship.
23 report.
Yes, of the year 8, 12 and 23, that is the report as the petitioner appellant is alive, your lordship. And matter is ready for hearing, your lordship. And earlier
Appeal
matter
appeal is ready. Who is appealing? The appeal is ready for hearing. However, none has appeared for the appellant. In the last 2 occasions also, none had appeared. In view thereof, the in the interest of it is urgent to so on the next date of hearing, if nobody appears, amicus curiae will be appointed. Yes.
34.
34, your last yesterday, your lordship kindly directed to me to verify exclusively the role of the present appellant in the involvement of the alleged crime, Your Lordship. So far, I am relying the statement of the PW1, Your Lordship, who is the mother of the deceased, Your Lordship, also an informant.
PW1.
Yes, sir.
Okay. Let us read. What's the name? Rajat Kumar Sahu. He is Rajat. PW1, huh?
That, Your Lordship.
Yes.
The
Read it.
mother of the deceased and so also the informant.
Yes.
Let's say I have two sons. One is Punarendra Patnaik, who served in the department. Another son is Harichandran Patnaik, the deceased. The farmer is my elder son, and the latter is my younger son. Harichandra Patnaik has been murdered by this accused Kumpa. That is the present appellant. The witness identified the accused in dock. Harichandra Das, reading in class IX, when murdered. He was murdered about 7 years back in the evening time. At that time, he had been to the shop of Kirtan Pradhan to bring mixture. Hari had owned a toy wrist watch when went to bring mixture. On the way, accused Kumpa asked him about the time. He annoyed on it. Then this accused, along with the Juria, another accused, son of Yudhishthira Sahu, and Prabhana is also an accused, son of so-and-so, quarreled with him and heard about the quarrel in my house. On hearing this, immediately I proceeded to the spot and saw this accused Kumpa along with the Juria and
They are assaulting.
yes, were assaulted.
Assaulting my son.
The accused and other two, the accused and other two, but the appellant and the two dealt fist blows to him, to the son of the present PW1. He didn't sustain any visible injury on his person. Therefore, I gave affair to the police, which is scribed on Prakash Kumar Bhasan. That is the mother of the victim, and that was corroborated by PW4, who was the owner of the shopkeeper.
PW
Should not read evidence in chief.
Evidence
and cross-examination.
Yes, I am also relying this question on the Lordship.
Yes.
Yes.
Juria, Kumpa, Juria, and
Kumpa Juria, and another one is
Pavana.
that is Juria and Pavana.
Pavana. ठीक है.
That's my learned senior is realm. Directing for pressing the crossing part. Due to my old age, now I am not able to see well in the night. But for last 10 to 12 years, accused Kumpa, Juria and Pavana are the playmates of my son Hari. I was in the house when Hari went to bring mixture. The shop of Kiran Pradhan situates intervening one, Patnish and 2 houses from my house. Some boys informed me that Hari was killed. Immediately I rushed to the spot. 20 persons are already gathered before my reaching there. Hari shouted for drink, saying "Bow" morally on seeing me. He also asked me to give water. Hari was lying down on the ground. I rushed to my house to bring water. When heard he is requesting for the water, at that spot, he died and couldn't drink the water. That is the question part. So far, I am relying the statement of the PW4, who is the owner of the shopkeeper.
What is the take of this witness? In the chief, he says that I have seen it. They were assaulting. When it comes to cross, he says that I got the information. When I went there, 20 people had already reached. That means he has not seen the assault part. And assault, he says that assault by 3 people.
Yes,
Juria, Pavana, and
Kumpa, present appellant.
In examination, see. And in the cross examination, his versions are altogether different.
To that extent, I am relying the statement of the PW4 on why the present PW1 stated so.
Let us see.
That is the Kirtan Pradhan, your lordship, PW4, your lordship, the owner of the shopkeeper to whom Jaitla mixture. I know the accused who is in the dock. I know Hari Chandra Patnaik, the son of late Sudaram Patnaik of my village. Relevant part, yes. On date about 7 p.m., the deceased, next paragraph 2, Hari came to my shop, and at the same time,
accused Rajat also came there. He teased Hari, and so both of them indulged in a quarrel. Hari had owned a toy wristwatch and accused Rajat teased him on that. I drove out both from my shop at a distance of 10 to 15 cubits from my shop. Other 7 to 8 boys came, and after some time, Hari shouted, saying, Marigali, Marigali, Marigali. On hearing this, I went to him and saw him lying in the ground holding his belly. His mother, Pidul1, was found there, and then I came back to my shop. Later, I heard that Hari
His
died.
story is altogether different.
Again, due to the said incident, Your Lordship, there is a quarrel
In the entire narration in Para 2,
Lordship.
he has not mentioned the name of
No.
accused.
I am only trying to bring the notice of the Honorable Court. Prior to the said incident, there is then quarrel with the son of the present deceased and
With
two
Rajat.
persons.
With Rajat.
Lordship.
With Rajat. Quarrel with Rajat.
Three, Your Lordship. There is three men. Name is three men.
No, Rajat. He quarreled with Rajat
both of
because
the-
he was teaching.
And
Thereafter, 7 and 8 boys came. After some time, Hari shouted, Marigali, Marigali.
Lordship.
Where is this accused in the entire story narrated here? Must be with out of this 7, 8 boy, he may be one of them.
I'm that part is there is no where mention. I am only to bring the notice that in the presence in the front of the shopkeeper owner, there is a quarrel, and they takes the name of the three. Lordship, my mother has taken the name of the three.
See, I'll tell you, there was a quarrel.
Okay.
The boy has somehow died. Okay.
Lordship.
But the question which we are searching today is,
Yes, Lordship.
who is responsible for it?
Yes.
Nobody is disputing that he has not died.
That
Nobody is disputing that quarrel has not taken place.
That's it.
Quarrel has taken place. 8, 9 boys came and something happened as a result of which he had died. But we are struggling today to find out who is responsible for it. Because the trial court says nobody else is responsible, he is responsible. This boy is responsible. In that context, you have to read the evidence.
Yes, Your Lordship.
Read the evidence in that context.
And doctor has not opined that death is homicidal.
So therefore, did you follow? Don't read. The story is correct. The narration of story is absolutely correct.
Yes, sir.
There is no doubt about it. But where in the story, where this boy is fitting? Come to the cross-examination of the same witness,
Right.
PW4.
That's
Nothing in the cross-examination. Then in the entire cross and chief, he has not taken the name of the present appellant.
name of the present
At
appellant.
all.
Except
Next
mother of the deceased.
next witness, PW.
5.
5, Your Lordship.
Nothing has been said.
5 no decline.
PW5. Let us read PW5.
Nothing has
There's
said.
nothing,
The
but
cross
they have
examination
declined, Your
also
Lordship.
he has not said anything.
Let us see. Read it.
Lordship, relevant part, Lordship. Known the accused who is the duck in the year 1992, I was a forest guard of Khalamanda beat under Nuaga PS. The occurrence took place in front of my beat house on that date about 7:30 p.m. The mother of the deceased, Hari Patnaik, called me loudly, and so I came out and saw her son was lying on the ground and rolling. I brought water from the nearby well and sprinkled on his face. Then I myself and Abakas lifted him and
Yes.
kept him on our veranda. There is no, I am not, PW5 is not aware, but only I am relying this statement of the PW5, PW1, Your Lordship, the mother of this is taken the president.
Let us see,
And though he is
PW1,
not
okay, whatever you are saying, I am accepting to be correct. Let us find out any evidence on record to draw a corroboration with the evidence of PW1.
And that is,
Show me any evidence.
no, that is not there.
Then what else there? Let us see the doctor now.
PW7. PW7, Your Lordship, doctor.
PW
7.
7 doctor. Yes. तो सुनिए. What is his opinion?
He has not stated about the death is omission. That is the minimum thing which my lord has was pleased to observe in the recent case. I was going through 2023 SCC online Orissa 5627. My lord is from the south. In deciding a case like this on circumstances.
See, there is some there is semblance of some evidence. Otherwise, how
Death
do
is
you-
my lord 3. I was saying my lord friend during recess. Three homicidal, accidental, or suicidal.
Hmm.
So at least minimum opinion should be it's a
There's
homicide.
something, huh?
To frame charge under section 302. It's not a case of 323. My lord, the law is very clear and well settled. Follow the crime, hire the proof. And here I'm the boy of 17 years or 18 years during that period. He has faced a trial of 302. It's not a child play case of 302.
It might be something might have happened. The children must be playing.
And
It fell down.
yes.
He must be suffering. Something might have happened.
Yes, my lord, it's a clearly suggested the pillar. My lord, altercations were there. Some quarrel was there. Can it be, my lord, stretched to
Young boy, there is no intention. They were playing. Young
yes,
boy.
and he, my lord, fell on a that is pillar where my lord, the cows are being tried there in the village. And he admitted, IO has also admitted that, and doctor has also stated that this injury is possible by that.
Hmm.
But a case of 302. And deceased was 18 years and appellant was 17 years. And all they were friends, village friends.
On this section, it was found that there was
Even the 302 re which are trial
1.5 liters of blood clot, and there was a linear fracture of bone. So, for the right lab of vertically, the injury was antemotum in nature.
The bottom but
the title to run force
homicidal
and is sufficient to cause death of the person in the ordinary course of nature. The death
Homicidal
was
nature.
due to the shock and hemorrhage with the
Homicidal nature.
injury in the liver, and he has
Antibiotic মানে before postmortem injury টা হয়েছে before death
and the same set of witnesses are disbelieved insofar as Pavan and Juria is concerned. If PW1 is to be believed, Pavan and Juria, how can you accuse them?
exonerated.
PW1 says that Pavan, Juria and this accused has assaulted.
But they were
Only
exonerated from
PW1 says.
let's say.
On the cross-examination, she gives a different story.
Different structure.
And apart from that evidence, there is no other evidence. And if that is the evidence to be believed, then Pavan and Juria should have been convicted also, along with this.
They were exonerated from by the law.
No charge has been tried. पड़ी जाएगी तो खुंटी ऊपर है
He might have fell down.
yes down पड़ी जाएगी से कुंडरा
मारामारी होती है, पड़ी जाती है उसे मारा जाती है।
अंदर राती what PW4 says it was a dark night and the pillars were fixed on the village under to tie the bullocks.
And there is no intention, there is no
Nothing,
motive, there is nothing. They
Even
were,
Fijuru, I was
and the
also-
mother also says that he is a playmate. All the children were playing,
Playmates.
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 So there is no enmity, there is no motive, nothing.
Toy watch been there, पता नहीं कितना अच्छी.
Hmm.
Say to
Twist करके ताकू ये
say to
करके-
$100.
And small children, they fight for this kind of thing.
Toy watch true.
Yes.
You has given the statement kindly glance for a moment.
No, come to para 8 of the judgment. It deals with that. I have read it out.
Yes, sir.
I have already read it. Para 8 and 9.
Clearly.
The assault has been made on the belly on the deceased. The PWs 4 and 5 have consistently stated that the deceased was rolling on the ground, holding his belly and shouted, saying Marigally, but they have not found any visible injuries on the belly. Dead body in presence belly, dead body in the presence of the witnesses, and the ascertained from the witnesses that the death of the deceased was due to assault. The inquest report is Exhibit 7. The PW 7 conducted the autopsy examination on the dead body and found as follows. He found there are no external injuries on the body except one injuries of 5.25 centimeter present over the upper part of the right side of the abdomen. On dissection, he found the abdomen cavity was contained. Dissection. Abdomen cavity was contained 1.5 liters of blood cloth, and there was a linear rupture of 6 cm.
Linear rupture 6 centimeter into 6.5 centimeter over the right lobe
over the right lobe of the lower situated vertically. The injury was antemortem in nature and could be caused by direct blunt force impact and sufficient to cause death of a person in ordinary course of nature. The death was due to shock and hemorrhage as a result of injury in the liver. He had opined, that was to a query of the prosecution, that if successive fist blows are given on the belly of a person with a heavy force, this injury inside the belly is possible. The PM examination report is Exhibit 6 in the cross-examination. He has stated that if a person will fall on the blunt object, the bruise on the abdomen is possible. Bruise on the abdomen is possible.
Come to 9.
Yeah,
9.
Yes.
Thus, from the evidence of PW
7,
it can be seen that
if the fist blows are given on the
blows are given on the belly of a person successively, who has said fist blow? Who has seen giving fist blow? Any witness?
That opinion was sought for, and he has asked.
Anybody has said that they have seen giving fist blow by the accused?
Nobody has deposed that.
Then
but
where from the fist blow?
PW1, the mother came.
See only Pawan, the peasant petitioner, and Juria were assaulting my son.
And
only that much in the examination in chief. And in the cross examination, she diluted that also. So forget about cross examination. The cross examination chief also you believe it. Then where is the question of where from they got that fist blow? How the doctor, how the trial court got this story, fist blow? Which witness have said that they have seen that this boy was giving fist blow?
PW1 ଯେତେବେଳେ ସେ ପହଞ୍ଚିଲେ ସେ ପିଲାଟା ତା ପେଟକୁ ଧରିକି ସେଟା ଗଡୁଥିଲା ମରିଗଲା that is there but not
କଥା ଭैया
I am not that is
everything you can't presume.
ପିଲାଟା ମରିଗଲା
See, the trial court records, neither PW1 nor PW2 have stated that they have seen accused dealing with the fist blow.
Court has
So
also
the value
reached
of the resulting the
court
cause
has
of
also
death,
reached a conclusion
that
in the
become
case.
a proximate cause of the
Sudden
victim of
problem.
death. But however, then the witnesses have not seen the physical assault. But PW4 stated that by the time they reached near the victim found was present so and so, so and so. All these things, what is this logic? Nothing.
Well, if considering the case of Sarad Milchan versus State of Maharashtra, which Maharashtra has also taken note of, 84 Supreme Court 162.2, that Panchashil Nit. That is, well, all the circumstances should be so well dated that unerringly pointing to the guilt of the accused. Where is that in case of 302?
It's the only you are drawing inference. The trial court has drawn inference. This might have happened, that might have happened. So many things might have happened. Where is that judgment? Get which paragraph?
My reference, yes, it is in paragraph 22 and 23.
You're reading open this part, huh?
Ballot.
Para 22.
22 and 23 with regards to homicidal part. Nothing is there that death is homicidal. So it can be accidental. It can, in the present
Maybe.
case, it is accidental.
We don't know what.
Ballot.
Para 22 and 23. Anything to say? Yes, Subhlakshmi, you want to say anything? No, try definitely.
Says that when it is a case of 302, where the maximum sentence can be hanging. So it should not be tried in this fashion.
Hmm.
And
what is the sentence undergone this boy might have gone?
1 year,
2 months.
1 year, 2 months. In that respect, if madam wants to convert this part 304 part 2 to 324 or 325, Supreme Court, this husband of Honorable Apex.
No, if it is a case of acquittal, why this boy? He's a young boy.
Young.
See, we can't spoil his life like this. If it is not a case of acquittal, then we try to find out way out to how to not
acquittal, madam.
clear case of acquittal. Yes,
This one.
because it is a case of acquittal. Therefore, I am asking you if you want to say anything.
I'll give the written
Written note, yeah. Right on. The appeal is heard. This is heard and on the let counsel for the state seeks an opportunity to file a written note of submission. Within
by Monday.
By Monday. Okay. By Monday. Take it. Reserve. Yes.
2022.
Find out anything if you have.
Yeah, Lord, sir, I will give by you a written notes for my Lord, sir.
35.
And keep it in mind that the other people are acquitted of. All of them are acquitted. And discharged or acquitted? I don't know.
Other two accused already been discharged by the Land Trial Court, Your Lordship.
So this boy having nothing.
The Land Trial Court come to hold that there is the quarrel between the present deceased
Quarrel, the other witness.
and there is then sudden kick blows. to
The
his
other
back.
witness very categorically says that quarrel is with Rajat.
Yes, that.
Where is Rajat?
Hmm.
Where is Rajat? PW7, no, PW5 says that the quarrel has taken place with Rajat. Rajat is also not right. No.
No, present here is the Kumpa, Rajat is the same. Rajat and Kumpa same.
Kumpo and Rajat same.
Yes, same. Rajat Kumpa same.
Okay.
Same. Kumpa Rajat is the same on one.
Merely because they picked up the quarrel, therefore it might have happened. That's the logic. Okay. No. Find out.
Rajat alias Kumpa.
Rajat alias Kumpa.
Same.
Okay.
Same.
You give.
Yes, Your Lordship, I will give the written notes.
35.
Thirty-five. 52. Nobody is there. Call for a report and 2.5 years. Give in August somewhere. Yes. 36.
36.
36, Your Lordship.
Huh?
Whole appellant at the time of filing appeal, appellant was 32 years. Conviction.
36.
Yes, at the time of 2005.
No, 36.
Hele ebe 32, sorry, 32. ବର୍ତ୍ତମାନ ହେଲେ
No, 36, there are three of them. Three of them. One was 40, 2005, one is 36, one is 23. 60, 56 and all. Call for a report.
Yes.
No, it is it's only 6 months. Why unnecessary? Non-APS, call and MK school will be appointed. Short date than 6 months unnecessary. Boda mein tuda parko. Yes. 37.
30. That's what it is. 38.
8 million. The present appellant has been convicted under section 379. The sentence is runs for a period of 1 year with fine of 1,000 rupees. It is alleged that on the day of the occurrence, one informant Dilip Kumar Devri of village Kandhabinda had given rupees 2,000 to his brother Pradeep Kumar Devri,
Hmm.
who was on his way to pay the money when accused Patita Sahu, who has been acquitted in the present case, is the main accused, and three other attacked him and took away cash of 2,150.
Hmm.
The present appellant and others were placed under trial, and the charge was under section 394 and section 325 of the SC/ST
Yes.
PO Act.
Hmm.
Thereafter, the learned trial court acquitted the accused persons of 394 and 32B of SC/ST PO Act, and thereafter convicted the present appellant
1 year,
again
1,000. 1 year, 1,000.
1 year 1,000.
Let us see the reasoning.
That's at page 7 of the interim judgment may kindly see. Para 9.
Hmm.
6 lines from the bottom. This is about the injuries,
Yes.
This is the
Para 9.
discussion about the
1 minute. Yes, para 9. Para 9, yes.
Para 9. PW6 is the testimony of the doctor, who examined the injuries.
Here, 4 accused person trial faced under section 394 and 3 SC/ST also. But only one present appellant is convicted under section 379. So, for 379 concern is whether it's made out that to be. My learned friend is reading the statement of the doctor. Injury report.
Injury report is not.
PW1 is the injured Pradeep Kumar Devri. The person who was carrying the money. You have to show the court that his testimony is.
Yes, yes, yes.
That is why I was placing it. 6 lines from the bottom. The injuries are also possible by fall or accident. She has categorically stated that such injuries cannot be possible by a bhujali having a sharp cutting edge. These injuries cannot be possible by thenga. These are the weapons that were alleged by the injured to have been used by the accused person. Next page, Milords, at page 8. I'm only showing the inconsistencies. Page 8, Milords, 10 lines from the top, Milords. Pradeep Kumar Devri, that is PW1, who is the injured witness, sole identity, has been examined as PW8 at para 10 of his cross-examination. He has categorically stated that on dated 14/6/2001, he has not been assaulted by any accused person. So going 390.
That's the only evidence is that found in the case of regarding the assault.
Regarding assault, mean of lateral visual is that of PW1. And PW1's evidence has been discarded by the doctor who's PW6.
Come to para 9 at 10.
Yes.
Applying the principle that it is seen that the prosecution has examined PW2, the brother of.
The paragraph before that, Milord, page 9, in such a situation, court has to rely on its robust common sense and trained intuition to decide the culpability of otherwise all accused persons. It is further noted that hardly we come across witness who do not add embroideries to his testimony.
Where are you reading?
Milord, page 9.
9.
Page
Okay.
9, Milord, above para 10.
Hmm.
It is further noted that hardly we come across witnesses who do not add embroideries to this testimony, but such little additions to the prosecution story or the truth do not make him an inherently unreliable witness. Such a situation, courts are expected to shift the evidence so as to separate the grains for the chaff, and in such a process, an entirely new case completely divorced from the case of prosecution is not found out, and the court can record a conviction with the reference. This is because they have convicted the present appellant against in under 379 minutes. The brother of para 10 minutes, applying these principles, brother of the injured has established a strong, this is as respect to the present appellant minutes, that they had rupees 2,000 which the present appellant has apparently snatched.
Read it. After some time, his brother written and told that the accused Potai Siri and
Piri,
Didi
Babi,
and
Pratsan abused
Prasanna.
him, saying such and such, and dealt blows on him by means of dhada, and also snatched away cash from his pockets. Therefore, PW2 proceeded to lodge a report at Jhargadi outpost. He went to the outpost at 1:30 p.m., but the officer was not there. He waited and lodged the report at 10 p.m. Because there is a gap between the registration of FIR. 1:30 p.m., then 10 p.m., almost 10 hours.
Yes.
Relying upon the reported decision of Ratan Singh versus State of Himachal Pradesh, learned PP contended that the statement made before PW2 by PW1 shortly after the occurrence shall be relevant under 6 of the Indian Evidence Act. Then they
So
have
the
discussed the
only
illustration as per
corroboration
section 6, Milords.
PW1 received is from the testimony of his brother PW2. Firstly, the PW2
Who
has
has corroborated the fact
the
that he had given PW1 rupees 2,000 plus 150 for repayment for mutton.
for the repayment of for the purchase of mutton. Immediately after the occurrence,
Occurrence,
PW1
had
has
come
come
and
and
complained
has,
before PW about occurrence
complained
that is
before
cogent.
the PW about the occurrence.
This PW1 and PW2 are brothers, Milords.
Thus, there is a cogent and clear evidence regarding the fact that one of the accused, namely Sri Sahu, inserted his hand inside
That is the
the
present.
pocket of the victim and snatched away the money. And I have already disbelieved the case heard to the witness. So now, offense under 394 of the provided punishment so. Yes.
The learned. Next page, page number 11, Milords.
As the 394 offense of the same is lesser offense. Hence, in the absence of any specific
That in order to
also court can record a conviction in the course of hearing this argument is in place. $394 is not believed and 379. What is the undergone period?
Undergone period, Milords, I'll have to
Find out from there. Just see the incident happened when. Two 2001. Sahu. What Sahu you are? Theory. Either Sahu. Undergone period you tell.
He's been released on bail by order dated 16th March 2005.
See the charge sheet. Charge sheet front page when you are arrested. 16 March 2005.
The bail order is there.
Petitioner was all along bailed and they did not initial bail court.
LCR is not there. Only the High Court report.
TCR is there, just see it from TCR if you can get some. From TCR, just see. The item 36. TCR. TCR. Surrendered in the court on 9/7/2001. 9/7/2001 surrender. 9/7/2001 surrender. Surrendered, huh? When he got bail. NBW issue on 27/6/2001. Surrendered. 7. No, he surrendered on the same day and he got the bail on the same day. He's not undergone bail. After conviction, he might have gone sometime, but when the judgment conviction?
Conviction, that's
28/1/2005.
28 January 2005. Paid by order 16/3/2000.
No, when the MP not here.
This honorable court order.
You people should do this exercise. You are wasting my time.
Let me.
This much minimum you can. If I can find, why not you?
Let me call the other, but I'll on the side, I'll find out.
Wasting my time. 28th January 2005. This
Well-
much level at least you should do.
Because he stayed for 2 months. After conviction, 2 months he stayed. 28 January 2005 was the order of conviction.
Was he taken into custody? Just see. Read the proceeding dated 28/1/2005.
Let me see this honorable court's order sheet dated.
I have seen that. Read that whether he was released on that day, on that day when judgment was pronounced. What was the sentence?
For 1 year and.
But then 389 benefit he might have given also. Let's see.
Mr. Mitra.
Check it. This exercise you have to do, not I.
I'll check.
Check it and tell me right now. Whether
Universal. Universal.
Obviously.
Balance it down. Fundamental instead of
These things you have to learn how to read the trial court record. If how I could found it. He surrendered on NBW was issued, then he surrendered. The day when he surrendered, there is a proceeding. He prayer for bail is granted. That was the same day he was granted bail. Now the question is, after conviction, whether he was taken into custody or not, because this court has given bail. After custody, bail is granted or not. And the routine orders are being passed here. Just check it up if custody was taken or not.
And in criminal appeal, during that period, if 5 years conviction, there was no hearing at all.
They generally common orders are being passed. On that basis, you can't decide. Just see, check it. When the judgment was pronounced by the trial court on that day, what was the order passed? On the proceedings. Judgment is separate. Proceeding, there is an order. Check it up. Yes. 90% of work you will learn out by reading the old records. Yes.
41.
And every machine 29th and 30th. All of your matters are listed. Come by 10 o'clock. Prepare a note in every case, undergone period, by recording, by seeing it. 9:45 also. 9:20, the court is open. If all the documents are here, one after another, you prepare a note so that you can give him immediately. We will not waste time. Okay. Yes, 30. 41.
Sole appellant initially faced trial under section 498/302, but conviction was made on 323 and fine of rupees 1,000 only.
Call for a report.
Yes, sir.
Sorted those.
58.
7 years. And 42 also call for a report. 42 also.
42.
Call for a report.
Yes.
43.
43, anybody is there? Non-APS, 43. MX will be appointed in the next database. Okay.
44.
44. Non-APS, MX will be appointed in the next day. 45.
45.
Call for a report. 83 years.
Yes, sir.
46 also call for report. 79 years. And
What is it?
Died, my lordship, they have given the death
you have a report?
46, 47, no.
Death
48.
certificate has been- They have taken a time, my lordship.
But report you have to ask.
Yes,
Huh?
sir.
Okay.
But I have to verify the death certificate.
40?
48.
48, anybody is there? No. Nobody is there. 10. Moses will be appointed. 49.
9.
Wait, please, your lordship.
Yes, sir.
On behalf of Mrs. B. Das, I pray for 4 weeks time. He sees on accommodation.
2005 matter, you get ready, why 4 weeks?
Yes.
There is a week. Adjournment, so and so is seeking adjournment.
50.
Hon'Ble.
50. Nobody pays, huh? I make it will be appointed 50.
51.
Yes. 51 also, nobody appears. MHS will be appointed at the next data. Okay.
52.
52. You have to ask, get a report, 52. 92, 93 years. 53.
53.
Yes, madam. 53. Then another. 53, nobody appears.
In 52, report would be required.
No. 52 report, but 53 is only 39 years. Why report?
394.
You are appearing?
For item number 53.
Yes, I am asking 53. What do you want?
Sir, on behalf of Mr. Chan, I would like to seek for adjournment. He is in Bhubaneswar.
Last support because on behalf of Mr. Chand. Okay. You get ready. What is the problem? Small matter. You can get ready. Sort it. Okay. 54.
54.
Call for a report here. Yes. 55.
56.
56. Anybody is there? 56.
He was 30 in 2006. He must be around 50, 55 years.
Nobody is there, huh? MK school will be appointed next set. Yes, next.
59.
57 and 50. 59, you have to get a report.
57, 58 years.
Urgent, huh?
Mention.
Mention it. 59, you get report. Yes. So that means he is not undergone at all. I'll put it on Tuesday. Get a judgment or whether and 379 conviction. Probation can be granted. Get the judgment. Okay? Get the judgment. Thank you.